This lesson deals with both prosecution and defense counsel who do their job so poorly that a wrongful conviction takes place. Firstly, with respect to the prosecution, it is exceptionally important that the defense has full disclosure of all the evidence in the hands of the prosecuting attorney, both inculpatory and exculpatory. Many studies and inquiries have concluded that the lack of proper disclosure is a systemic cause of wrongful convictions. For someone who is innocent of a crime and therefore has no idea what facts are in the hands of the police at the time the charges are laid, it is exceptionally important that the case is disclosed so that the defense has the opportunity to properly mount their case. The requirement of disclosure is constitutionalized in the USA case of Brady versus Maryland.
It is a feature of our criminal justice system that each defendant must receive a fair trial. For that to happen, the defendant's attorney must have access to appropriate potential evidence. To ensure this right, the United States Supreme Court has ruled that prosecutors must disclose exculpatory evidence, which means evidence that tends to demonstrate innocence. This rule was announced in the 1963 case Brady versus Maryland. In that case, John Brady and his companion Charles Boblet were accused of robbing and killing another man. They were arrested, tried separately, and each convicted of murder. To avoid the death penalty, Brady took the stand and admitted to participating in the crime, but claimed that Boblet killed the victim. To support his client's claim, Brady's defense attorney sought to examine all statements that Boblet made to the prosecutor. Although the prosecutor gave the defense attorney access to these statements, he did not provide him with the one statement dated July 9, 1958, in which Boblet admitted to having committed the murder. Prior to that time, a defendant's rights were only considered violated when a prosecutor behaved in bad faith by intentionally concealing exculpatory evidence or intentionally allowing false testimony at trial. The court's decision in Brady altered the criminal procedure landscape. Although the state prosecutor did not conceal the statement of Boblet out of trickery or intent to deceive, the court reasoned that any concealment of exculpatory evidence violated Brady's right to a fair trial and established the rule prosecutors must turn over, upon request, all favorable evidence that materially relates to a defendant's guilt or appropriate punishment. The Supreme Court in Brady did not define material or offer guidance on how a defense attorney's request for exculpatory evidence should be worded. Later decisions have attempted to clear up any confusion. In Giglio versus United States, the prosecution's primary witness provided nearly all the evidence that established the defendant's guilt. However, the prosecution did not disclose the fact that his testimony was obtained in exchange for an offer of leniency. The Supreme Court determined that this leniency offer was material, and withholding that information from the jury and from defense counsel violated the defendant's right to a fair trial. The case established that evidence is materially exculpatory if it would have reasonably affected the judgment of the jury. Here, the evidence of the leniency offer could have affected the jury's conclusion because it could have cast into doubt the witness's credibility. The court further ruled that it did not matter whether the prosecution intentionally withheld this evidence. Even if it were held negligently without bad faith, it still violated the defendant's due process rights. The defendant was therefore entitled to a new trial. Material has been subsequently defined as a reasonable probability that if the evidence had been disclosed to the defense, the outcome of the trial would have been different. The reasonable probability language must be sufficient to undermine the confidence in the outcome of the case. In United States versus Bagley, the government charged a defendant with firearm and narcotics offenses, and the defendant was eventually convicted of the narcotics offenses. Prosecution did not disclose that the primary witness in the firearm prosecution was a paid informant. This fact, however, was not considered material to the narcotics offense conviction. The court reasoned that there was not a reasonable probability that the outcome of the case would have been different because the informant was only compensated nominated for testimony relating to the firearm offense, which the defendant was acquitted of in any case. The Brady case itself did not set out how a defense attorney's request for materially exculpatory evidence should be worded. Now, however, the Supreme Court has made clear that prosecutors must turn over all materially exculpatory evidence in all circumstances, even when defendants do not ask for the evidence. Some prosecuting agencies issue guidelines on what evidence prosecutors must disclose and how they should disclose it. Other prosecuting agencies have adopted open file policies, where a defendant can access a prosecutor's entire case file. There are several possible consequences if a prosecutor does not comply with her obligations under Brady. A court can order a new trial if the failure to disclose the information could have made a difference in the initial trial. Second, the prosecutor may face disciplinary actions for violating the responsibility to disclose exculpatory evidence. For example, former Durham County District Attorney Mike Nafong was disbarred, in part, for failing to disclose exculpatory evidence in a high-profile Duke University lacrosse case. Finally, if a court finds a pattern of Brady violations in a district attorney's office, a prosecuting attorney could be subjected to civil rights lawsuits. Brady v. Maryland is a landmark criminal procedure case that rivals Miranda v. Arizona in importance. It seeks to ensure that criminal defendants enjoy fair opportunities to defend themselves by providing them access to information that tends to show their innocence.
The comparable case from the Supreme Court of Canada is called Stinchcombe. Similar disclosure requirements are found in the UK, Australia, and other common and civil law jurisdictions. The rule can be described as a legal duty to disclose all relevant information to the defense. The fruits of the investigation, which are in the possession of the prosecution, belong to the public in the pursuit of justice and not to the prosecuting attorney for the purposes of a conviction. Statements obtained from persons who provided relevant information to the authorities must be produced, even if they are not proposed to be called as witnesses by the state. We now turn to ineffective assistance of defense counsel. Convictions overturned as a function of DNA evidence have revealed a list of cases that included drunk, sleeping, overburdened, and incompetent defense counsel. The examples of poor defense work have included lawyers sleeping in the courtroom during a trial and appeal, a failure to follow up on a client's assertion of an alibi, a failure to call and consult with experts who can challenge the prosecution's evidence, and even failures to show up for a trial. It can also be said in the strongest of terms that governments who fund legal aid to assist accused persons who do not have the financial means to pay for their own counsel are failing miserably in providing assistance. When a convicted individual decides to seek exoneration due to a shoddy defense, the applicable test contains both a performance component and a prejudice component. For this avenue to work, it must be established firstly that the defense counsel's actions or omissions constituted incompetence, and secondly, it must be shown that this incompetence led to a miscarriage of justice. Here are a few examples of cases involving ineffective counsel. For Anthony Hicks, his lawyer decided not to do a DNA test, which he never discussed with his client. The lawyer claimed he did not do so because he believed none of the serological evidence could be conclusively linked to the defendant. 2, he thought that the hair evidence would be inadmissible. And 3, he said the cost of DNA was prohibitive. For Ron Williamson, his court-appointed lawyer failed to investigate mental competency, failed to investigate the last person to see the victim alive, he didn't cross-examine a snitch, and he failed to introduce videotape of another person's confession. And lastly, Josiah Sutton's court-appointed lawyer told his mother and his family that he would need money to conduct independent DNA testing, which they paid, and who simply failed to obtain the testing and kept the money. The next video lesson is on faulty forensic science.